The Pietermaritzburg High Court will hear former President Jacob Zuma's application today to interdict Police Minister Bheki Cele from effecting his arrest. That's until the Constitutional Court has heard his rescission application. That's set down for the 12th of July. So this is in connection, of course, with the 15-month prison sentence handed down by the Apex Court. Let's get you some analysis now. We're joined by legal analyst Ulrich Roux. Ulrich, it's great to talk to you this morning on what is really uncharted legal waters in our country at the moment. Where do you place this move by the police minister, writing to the Constitutional Court? There's no legal papers that have been filed, but he's written a letter to the Constitutional Court asking that he's excused from effecting that arrest warrant come midnight tomorrow.
Hi, good morning, Michelle. Yes, certainly uncharted waters completely. But just to give some background again, remember that a court order was handed down last week, Tuesday, exactly a week ago, by the Con Court, saying that Jacob Zuma is to hand himself over to start serving his period of imprisonment of 15 months, and that he should have handed himself over by midnight on Sunday.
Yeah.
And if he does not, then the Minister of Police has 3 days within which to arrest him and to use whatever means possible, together with the police commissioner, in order to arrest him so that he can start serving his sentence of imprisonment. Since then, Jacob Zuma has obviously launched the rescission application, in which he's attempting to have convinced the Con Court to set aside their own order, but also for, as you correctly point out, for the Pietermaritzburg High Court today to stay the execution of the order. So in other words, telling the police commissioner and the Minister of Police not to arrest him until the rescission application has been finalized in the Con Court. So strictly from a legal point of view, the rescission application does not stay the order. So in other words, that order must be executed. Strictly also speaking from a legal point of view, and if you have strict adherence to the court order handed down by the Con Court, the Minister of Police and Police Commissioner have until midnight tomorrow within which to arrest him. And if today's application fails, then there's absolutely no grounds which prohibits them from arresting Jacob Zuma. So I think maybe not a bad move by Minister Bheki Cele, saying, please give us guidance, because as the entire country knows, this is uncharted territory. There's never been a Constitutional Court order rescinded and set aside. So please let us know, exactly what we should be doing. From a strictly a jurisdictional point of view, I do not believe that the Pietermaritzburg High Court has the jurisdiction to even hear today's application. Remember that the Constitutional Court is our highest court in the country, and now Jacob Zuma has gone to a lower court, the higher court, to ask to stay the Constitutional Court order. So it does not make jurisdictional sense, but we have been surprised before in this matter, so let's see what the court says today.
So yeah, that was actually my next question to you. It doesn't, as you say, make sense that a lower court can have anything to say about a decision taken in the Apex Court. In terms of hearing the matter in the first place, just for our viewers who aren't in the legal fraternity, the High Court was always going to hear the matter, whichever way it's going to decide, right?
No, not necessarily. The High Court, the judge could say, I don't believe that this court even has jurisdiction. I've not an opportunity to read the papers filed by both Jacob Zuma and the Commission, but I'm sure that the Commission is saying exactly that, is we don't even know why he's approached the High Court, because the judges can't hear the matter. Yeah. The judges need to abide by a Constitutional Court order, and they can't overrule a Constitutional Court order.
So why hear it in the first place then?
Exactly, we would have to wait and see today. So we could either be faced with a situation where the judge says to Jacob Zuma, Mr. Zuma, before we even entertain the merits of your application, please only address us on the jurisdiction issue. So convince us that this court has the jurisdiction to hear this matter. That could be the case. Secondly, the judges could just dismiss it and say, well, we can't even start this court case we can't even entertain an argument because we don't have jurisdiction. But we'll have to wait and see what the judges do. We either have a full bench of 3 judges in the High Court or 1 judge who will hear the matter. And, that is the choice of the judges.
So speaking of deciding to hear the matter, were you surprised as well, given that the Constitutional Court has made a decision on the contempt of court issue with regard to the former president, finding him guilty? Were you surprised that it once again opened the doors to him for the rescission application?
Yes, surprised is one way of putting it. Gobsmacked is another way. I think together with a lot of other people in the legal fraternity, we are extremely surprised that this application has even been entertained. I've been involved in numerous matters with the Constitutional Court, and the Constitutional Court has the power to simply say, Mr. Zuma, we don't believe there's any merit in this rescission application. We're not even going to entertain what you're trying to say to us. You need to start serving your sentence of imprisonment. Never before has the Constitutional Court rescinded or set aside its own order. And why this is bizarre in a certain extent, to a certain extent, is that the Constitutional Court heard the contempt application in April. They deliberated for 3 months. They considered every single legal avenue that there was to consider, and they handed down a majority judgment where 7 of the judges agreed that should be the finding of the court and the sentence, and 2 judges disagreed. And now, they are basically saying, well, Mr. Zuma, you've had a few days to file these papers to rescind our order, and we're going to disregard what we said, and we will, hear what you have to say on the matter. So interesting and uncharted waters indeed, as you say. But let's see what the court decides.
Yeah. Does it give you the sense that the court is not as it says or as it should be, in fact, not as blind to who you are and what your standing in society is?
Well, remember that we must at all times believe in the objectivity of our courts and our judges. And until the contrary is proven, we need to do that. We can't start with conspiracy theories as to why he's being entertained. The only reason that I can think he is being entertained is because it is a novel and a unique application that he has brought. But also we have the old dictum in South African law, and it's a beautiful Latin phrase, and goes audi alterum partem, and that means that there's always 2 sides to a story, and the court must always ensure that it hears both sides to a story. If there's more sides to a story, then the court should make sure that it hears all of the evidence available, and that is the only argument I can see the court justified itself by entertaining this rescission application. So let's hear what they have to say.
Yeah. Ulrich, I want to ask you one last question just about the optics of this case. I mean, the former president is approaching the court. The acting Chief Justice is now the person who is also chairing the inquiry, which he refused to take part in because of Deputy Chief Justice Raymond Zonder's supposed bias against him as perceived by former President Jacob Zuma. Zonder is now the acting Chief Justice. What are the optics around that?
It goes to whether he's conflicted in the matter. In my opinion, I think there is a conflict of interest. Remember that this contempt application was brought as a result of Deputy Chief Justice Zondo refusing to recuse himself and also insisting that Jacob Zuma must testify before the commission. So I expect to see him withdrawing from this application specifically. That does not mean that he's not the acting Chief Justice. It just means that he cannot objectively sit in as a Constitutional Court judge in this matter, because it could open the door for numerous arguments being made as to whether he's impartial and whether he's objective in making a fair ruling in this rescission application.
Yeah. Muddy waters. Ulrich Roux, as always, thanks so much for coming on and giving us some clarity on these various issues.